Pulau Batu Pete, Middle Rocks, and South Ledge, Malaysia, Singapore. During his long and illustrious career, Judge Srinivasa Rao served the Indian government at the highest level, heading the Legal and Treaties Division of the Ministry of External Affairs and acting as Chief Legal Advisor on International Law from 1985 to 2002, as well as represent his country at various international legal conferences. He was a member of the International Law Commission from 1987 to 2006 and was elected as its chairman in 1995. He also acted as arbitrator in the Bay of Bengal maritime boundary arbitration between India and Bangladesh between 2010 and 2014. That same decade, he served as first Vice President and President of the Institut du Droit International. He was also invited to lecture on law as visiting professor at various prestigious universities. These are just some of his many professional achievements in a life dedicated to upholding the value of international law as a practitioner, an advocate, a judge, and an academic. As a judge ad hoc at this court, Judge Srinivasa Rao is remembered with much fondness by his former colleagues who admired his ability to combine sharp, independent thought with a marked sense of collegiality. Judge Srinivasa Rao was a leading international jurist and a man of great integrity. He will be missed. On behalf of the members of the court and myself, may I offer our sincere condolences to the family of Judge ad hoc Srinivasa Rao. I invite you now to stand and observe a minute of silence in his memory. Thank you very much. Please be seated. I shall now turn to the judicial proceeding before the court today. The court meets this morning under Article 74, Paragraph 3 of the Rules of Court to hear the single round of oral arguments of the Republic of the Sudan on its request for the indication of provisional measures submitted in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide in Sudan, Sudan versus United Arab Emirates. The court included upon the bench no judge of the nationality of either party. Accordingly, both parties availed themselves of the right under Article 31, Paragraph 3 of the statute to choose a judge ad hoc to sit in the case. Sudan chose Mr. Bruno Sima and the United Arab Emirates, Mr. Philippe Kivrugo. Article 20 of the statute provides that every member of the court shall, before taking up his duties, make a solemn declaration in open court that he will exercise his powers impartially and conscientiously. Pursuant to Article 31, Paragraph 6 of the statute, the same provision applies to judge ad hoc, who have to make a solemn declaration in each case where they participate, as stated in Article 8, Paragraph 3 of the Rules of Court. In accordance with the court's practice, I shall first say a few words about the career and qualifications of Judge Sima and Judge Kivrugo, before inviting each of them to make their solemn declarations. Judge Bruno Sima of German nationality, served as a member of the court from 2003 to 2012, and was appointed as judge ad hoc in the joint cases concerning maritime delimitation in the Caribbean Sea and the Pacific Ocean, Costa Rica versus Nicaragua, and land boundary in the northern part of Isla Potias, Costa Rica versus Nicaragua, and in the case concerning the dispute over the status and use of the waters of Silala, Chile versus Bolivia. Judge Zimmer studied law at the University of Innsbruck, where he obtained a doctorate degree in 1966. In 1973, he became professor of international law and European community law at the University of Munich, where he went on to serve as dean of the faculty of law between 1995 and 1997. Judge Zimmer also has a long-standing academic career at the University of Michigan Law School, where he began teaching in 1986, was appointed professor of law in 1987, and where a chair was created in his name in 2009. He has twice been the director of studies of the Hague Academy of International Law, and in 2009, he delivered the prestigious general course in public international law. His publications in international law are numerous and well-known. Judge Zimmer was a member of the International Law Commission from 1996 to 2003. He has appeared as an advocate in various cases before the court and has sat as arbitrator in numerous arbitral tribunals. Since 1st December 2012, he has been an arbitrator at the Iran-United States Claims Tribunal. Judge Zimmer is the recipient of numerous awards, including honorary doctorate degrees. Judge Cabral, of Belgian nationality, served as the registrar of the court from 2000 to 2019, having previously held various positions in the court registry since 1982, including that of principal legal secretary. Judge Cabral studied law and philosophy at the University of Namur and the Catholic University of Louvain, before completing his postgraduate studies in international and European law at King's College London and Complutense University of Madrid. In parallel with his illustrious career at the court, Judge Cabral has taught law as a visiting professor and guest lecturer at various universities. Judge Cabral has also given courses at both the Hague Academy of International Law and the Sherman Academy of International Law. Since stepping down from his function as registrar, Mr. Cabral was appointed as judge ad hoc in the case concerning Guatemala's territorial, insular, and maritime claim, Guatemala-Belize, and in the case concerning the arbitral award of 3 October 1899, Guyana versus Venezuela, both currently pending before the court. He is also a judge ad hoc at the International Tribunal for the Law of the Sea and serves as an arbitrator in investor-state proceedings. Judge Cabral is an associate member of the Institut du Droit International, as well as a member of numerous learned societies. Throughout his outstanding career, he has authored many articles, monographs, and papers in French, English, and Spanish on a wide range of topics of international law and with a particular focus on the court. In accordance with the order of precedence fixed by Article 7, Paragraph 3 of the Rules of Court, I shall first invite Judge Zimmer to make the solemn declaration prescribed by the statute and I would request all those present to rise. Judge Zimmer, you have the floor.
Thank you, Mr. President. I solemnly declare that I will perform my duties and exercise my powers as a judge honorably, faithfully, impartially, and conscientiously.
I thank you, Judge Zimmer. I now invite Judge Cabral to make the solemn declaration prescribed by the statute. Judge Cabral, you have the floor.
Merci, Monsieur le Président.
Thank you, Mr. President. I solemnly declare that I will perform my duties and exercise my powers as judge honorably, faithfully, impartially, and conscientiously.
Cabral, please be seated. I take note of the solemn declaration made by Judge Ad hoc Zimmer and Judge Ad hoc Cabral, and declare them duly installed as a judge ad hoc in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide in Sudan, Sudan versus United Arab Emirates. I shall now recall the principal steps of the procedure in the present case. On 5 March 2025, the government of Sudan filed in the registry of the court an application instituting proceedings against the United Arab Emirates with regard to a dispute concerning alleged violation by the latter of its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide in Sudan, most notably in West Darfur. I shall refer to this convention as the Genocide Convention. To found the jurisdiction of the court, applicant invokes Article 36, Paragraph 1 of the Statute of the Court and Article 9 of the Genocide Convention. Together with this application, Sudan submitted a request for the indication of provisional measures pursuant to Article 41 of the Statute of the Court and Articles 73, 74, and 75 of the Rules of Court. The Registrar will now read out the passage from the request, specifying the provisional measures which the government of Sudan is asking the court to indicate, pending a final judgment in the case. You have the floor, Mr. Registrar.
Thank you, Mr. President. I quote, 1. The United Arab Emirates shall, in accordance with its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, in relation to the Masalit in the Republic of the Sudan, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of this Convention, in particular, A. Killing members of the group, B. Causing serious bodily or mental harm to members of the group, C. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and D. Imposing measures intended to prevent birth within the group. 2. The United Arab Emirates shall, in relation to the members of the Masalit group, ensure that any irregular armed units which may be directed or supported by it and any organizations and persons which may be subject to its control, direction or influence do not commit any acts described in point 1 above, or of conspiracy to commit genocide, of direct and public incitement to commit genocide, of attempts to commit genocide, or of complicity in genocide. End of quote.
I thank the Registrar. Immediately after the application and the request for the indication of provisional measures were filed, the Registrar transmitted an original copy thereof to the government of the United Arab Emirates. He also notified the Secretary General of the United Nations. According to Article 74, Paragraph 1 of the Rules of Court, a request for the indication of provision measures shall have priority over all other cases. Paragraph 2 of the same article states that the Court shall proceed to a decision on the request as a matter of urgency. This imperative must be, however, balanced with the need to fix the date of the oral proceedings in such a way as to afford the parties an opportunity of being represented at the hearings. The Court decided that these oral proceedings would be held today on 10 April 2025. By letter dated 3 April 2025, the agent of Sudan informed the Court that his government wanted to amend the measures requested in paragraph 22 of its request for the indication of provision measures, dated 5 March 2025. The Registrar will now read out the amended measures. You have the floor, Mr. Registrar.
Thank you, Mr. President. I quote, 1. The United Arab Emirates shall, in accordance with its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, in relation to the Masalid group in the Republic of the Sudan, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of this Convention, in particular, A. Killing members of the group, B. Causing serious bodily or mental harm to the members of the group, C. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and D. Imposing measures intended to prevent births within the group. 2. The United Arab Emirates shall, in accordance with its obligations under the Genocide Convention, in relation to the members of the Masalid group, refrain from any conduct amounting to complicity in the commission of any of the acts described in point 1 above, by any irregular armed units or by any organization or persons. 3. The United Arab Emirates shall submit a report to the Court on all measures taken to give effect to this order within 1 month as from the date of this order, and thereafter every 6 months until a final decision on the case is rendered by the Court. End of quote.
I would now like to welcome the delegation of the parties. I note the presence of the agents and counsel of Sudan and the United Arab Emirates. This morning, the Court will hear the single round of oral argument of Sudan, which has submitted the request for the indication of provisional measures. It will hear the single round of oral arguments of the United Arab Emirates this afternoon at 4 o'clock. Both parties have a maximum allotted time of 2 hours each for their respective oral presentations. At today's sitting, Sudan may, if required, avail itself of a short extension beyond 12 noon, in view of the time taken up by these introductory remarks. Before giving the floor to the agent of Sudan, I wish to draw the attention of the parties to Practice Direction 11, which states as follows, I quote, "In the oral pleadings on request for the indication of provisional measures, parties should limit themselves to what is relevant to the criteria for the indication of provisional measures as stipulated in the statute, rules, and jurisprudence of the Court. They should not enter into the merits of the case beyond what is strictly necessary for that purpose." End of quote. I now give the floor to the agent of Sudan, His Excellency Dr. Maiwa Osman Muhammad Khail. You have the floor, sir.
Mr. President, Madam Vice President, Members of the court, it is an honor to appear before you as the agent of the Republic of Sudan. A genocide is being committed against the ethnic group, the Masalid, in the west of our country. The Masalid are non-Arab African ethnic group. The genocide against the Masalid is being carried out by the Rapid Support Force, paramilitary Arab from Darfur, with the support and complicity of the United Arab Emirates. It was recognized during the drafting of Genocide Convention that the Commission of Genocide will, quote, nearly always involve the complicity of state, end quote. That is so in the large-scale extermination of the Masalid in the present case. The ongoing genocide would not have been possible without the complicity of the UAE, including through the content, sponsorship, and shipment of arms of RSF. The UAE continues to supply the RSF with increasingly heavy arms through cargo flight to Mjaras airport in neighboring Chad. Last year, 10,000 to 15,000 persons were killed in the RSF massacre of Masalid, population of Al Geneina in West Darfur. With increased firepower and support from UAE, the RSF has now leased siege to Al-Fashir in North Darfur. Al-Fashir contains large camps from 10,000 of entirely displaced persons from the Masalid tribe. The genocide violence that will ensue if Al-Fashir now falls and the RSF take it does not bear thinking. There is an immediate risk of repeat of extermination of Masalid at Al Geneina. The direct logistic and other support that the UAE has provided and continue to provide it to the RSF and their affiliated militia has been continue to be the primary driving force behind genocide now taking place, including through killing, rape, forced displacement, looting, and the destruction of public and private properties. Professor Bure will set out the fact. Mr. Warsu Kisi will address the court prima facie jurisdiction. Mr. Ogi will deal with plausibility. Then Professor Bilashi will deal with the risk of irreparable prejudice and the professional measure requested by the Sudan. Mr. President, I thank you and ask that you now invite Professor Bure to the podium.
I thank the agent of Sudan for his statement. I now invite Professor Eirik Bjørge to address the court. You have the floor.
Mr. President, members of the court, it is an honor to appear before you on behalf of the Sudan to address the facts. As I will explain, including by reference to UN sources, there can be no doubt that the Masalit people is currently being subjected to genocide, and that there is serious evidence that the UAE is failing to prevent this and is complicit. I will also deal very briefly with the existence of the dispute in case the UAE seeks to raise this as a point. It is notorious that since November 2023, the Masalit non-Arab ethnic group in the Sudan has been targeted and subjected to acts of genocide and other prohibited acts which continue to this day. The perpetrators of these acts are members of the Rapid Support Forces, the RSF, a militia comprised of Arab Darfuris, led by a former commander of the Janjaweed militia, General Mohammed Hamdan Daglo. The situation was accurately summarized as follows by the current US Secretary of State, the Honorable Marco Rubio, during his confirmation hearing before the US Congress in January of this year. By its very definition, this is a real genocide. This is the ethnic targeting of specific groups for extermination, for elimination, by groups, by the way, that are being funded by nations that we have alliances and partnerships with in other parts of the world, and we should express that clearly. I think, and part of our engagement with the UAE, and it will have to be a pragmatic engagement, I mean, they are important players in what we hope to resolve in the Middle East, and I think, as part of that engagement, we also need to raise the fact that they are openly supporting an entity that is carrying out a genocide. Against this backdrop, and in circumstances where the UAE's open support for the RSF continues, notwithstanding the fact that the RSF's ongoing siege of El Fasher is increasingly at serious risk of culminating in further acts of genocide, and the RSF's attacks against other gathering places in West and North Darfur for members of the Masalit people who have been displaced by the conflict have also escalated over the past month, the Sudan had no choice but to approach the court for urgent interim relief. It's important to understand why the current US Secretary of State felt able to express the situation in the forthright terms he used. In the spring of 2023, the RSF was increasingly capturing territory in Darfur. During clashes in El Janina in West Darfur in May-June 2023, the RSF and militias aligned with it carried out large-scale attacks on civilians, the Masalit population in particular. They conducted a systematic campaign to extirpate the city's Masalit community. The massacre by the RSF has been described as a deluge of atrocities and a killing frenzy. Between 10,000 and 15,000 persons were killed. In this and other atrocities, the RSF has targeted gathering sites for internally displaced persons, IDPs, which have been systematically attacked, burned, and destroyed. In November 2023, the United Nations Special Advisor on the Prevention of Genocide, Alice Wairumu Deritu, described the events in West Darfur, in the following terms: rape and other forms of sexual and gender-based violence, including sexual slavery, have been rampantly perpetrated as a weapon of war. Entire villages have been burnt, often with the plan to attack announced in advance. Derogatory and dehumanizing language, such as slaves, has been persistently used as an element of incitement to violence. Conditions of life have been deprived, with medical facilities and transportation destroyed, and access to water and electricity deliberately obstructed. This all points to risk factors for genocide.